It will be made available afterwards for you to also view if you cannot attend any of the webinars. Then it will also be available. Yeah, how many people registered? But I see there's 17 people joining at the moment. Sorry, has joined us so far. I see there's 2 others outstanding, so but let's start so long. Okay, so I said my name is Elizabeth Nieuwoud. I see from the names on the list of people in front of me, I know some of you and I've met some of you, and then some of you are strangers. So let me start with introducing myself so that you know who the facilitator is. Now, as I said, my name is Elizabeth Nieuwoud. I'm an advocate. I was admitted in 1994, and the past about 20 years, I've been specializing in representing children and in the Children's Court and in the High Court. And when, Lead approached me to do this course, I said, I want something that is practical, that you can use on any given day that you go to the Children's Court, that you go to court today with, say, or even the High Court, it doesn't have to be the Children's Court, but let's say you have a matter today that is on foster care, that you can go to this material that you have been given and you can look at the chapter of foster care, you can print it out, or you don't even have to print it out, but you can download it. And it is a quick guide to foster care. What is the principles? How does it work? How does it not work? What is a foster parent? What do they do? What can't they do? So really this course is really I almost want to say introductory level to child law. If this tickles your fancy and you say, Nashu, I want to know a bit more about child law, I want to go into deeper aspects of the Hague Convention, for example, or inter-country adoption, then there's a whole field that then you can go into to specialize in that. So this course is really to whet your appetite to see, is there something more that you want to learn about child law? Because child law, you'll see as we go through the material, is something not only applicable in the Children's Court, yes, but also in either other court, but also not in courts. If you look at some of the principles in the Children's Act that talks to circumcision, that talks to child ECDs, which is your early childhood development, that talks to drop-in centers. So those things are not even linked to a legal system, to a children's court or a high court, but it's all governed by the Children's Act, and it is all has one principle in mind, and that is to act in the best interest. But also it is there so the children can access the rights they have in terms of the Bill of Rights. So this is a basic starting point, and if it tickles your fancy, then you maybe know this is what I want to know more about going forward, and you can maybe enroll for further courses with LEAD or the Centre for Child Law with University of Pretoria or any other institution that you can say, okay, let me go deeper into the Children's Law, Children's Act, or whatever aspect of the Children's Act you want to go into. But before we start with the webinar, I like to know who I'm talking to. So if we are a few people on the platform, I see there's 21. So if there are people, I don't want to start picking on the people that I know. So if there's people that want to start, so just by maybe telling us a little bit about yourself. Are you an attorney, or are you a social worker? Are you a candidate attorney, or where you are and why you wanted to join the this course? I don't know who wants to start. As I say, I know a few people, so let me not pick on people. Marina, yes, I see you unmuted yourself. Yes, just go, Marina, yes.
Hello, my name is Marina Viljoen. Can you hear me?
Yes, I can hear you loud and clear.
So I've been a conveyancer for the past 8 years, and at the end of last year, I assisted a friend with a children's law matter, which was supposed to be very quick and easy.
Okay.
Turned out we went to the High Court for interim orders and so forth and so forth, and word got around, and now I'm faced with a lot of children's and family matters, and I think it just chose me. So now I'm
Okay.
doing everything I can to learn
Okay.
more about it.
Just to get more. Okay, yeah, because I think there's a big jump from conveyancing into litigation, and especially then children's litigation. Where are you situated, in which area?
In Lephalale, Alice Limpopo.
Oh, so you're now in like the hottest town in South Africa, almost also.
Yes, very, very near to hell.
I've been there before, and yeah, so I know the heat that you're talking about. But it's good. Yeah, I like people that outside the Gauteng area, because I think we also get inputs from how other courts work. That's important. Thank you for being for the first. Thank you for being brave. Daniel, sorry.
Hi there. My name is Daniel Marley. It's quite funny. We're actually dealing with you in one of our matters, so it's nice to actually put a name to an email.
I deny everything, and it wasn't me. Can I just place on record?
No, fair enough. Fair enough.
Okay.
I did insurance law for 4 years. I'm an attorney. And then I moved over to family law, and then I pretty much fell in love with it. And then I immigrated to Dubai for a few months, and it was horrific. And I came back and I said, I definitely want to continue with family law. And then, I was working in Sandton, and now I'm situated in Pretoria. So it's a different jurisdiction. It's a
different environment.
Yeah, absolutely.
No. Yeah. If I can speak up on behalf of all Pretoriaans, we're much nicer people than.
I'm slowly picking up, with that. But I'm used to all my Joburg advocates and all of that. Yeah. So it's a nice change. But why the reason why I want to do this course is just a refresher, and I think, just to see where we miss, or the certain areas that we actually don't know. So I think a nice refresher will be quite ideal. So thank you.
Yeah. Okay. No, I think also I must say this. I think all of us, if we have to go around the room and ask you, how long you've been admitted, you will maybe read some of this and go like, duh, I know this. But sometimes we really just to be reminded of some principles again. Yeah. Okay.
Absolutely. Thank you.
Thank you very much. Sekgofatso, I see your hand were up.
Good evening, everyone. Yes, so I was practicing for just over a year before I left practice. I specialized in labor law. That's what I did my articles in. I never rotated. So after finishing my master's in labor law, I was curious because my undergrad thesis for my LLB was on the right of children after divorce. So now I'm considering if I should do a second master's or if I should do a doctorate. So I just wanted to go back, like almost everybody else, just do a refresher course, see, if there is a gap here, something that I can build on, that I can work on possibly, or if I should stay in with labor. But I'm a lecturer now. I've been lecturing for over 4 years, and I'm in Widowput at IEMSA. Thank you so much.
Okay, good. Thank you for that. Yes, and then I see the next person in the row, Suzanne.
Hi, everybody. My name is Susan. I am an attorney in private practice. I was admitted as an attorney in 2010. I deal predominantly with family law matters in my practice, and the sole purpose for me attending this course is also for refresher purposes, because nobody knows everything, and we work in a dynamic field, especially when it comes to children, ever-changing needs and ever-changing circumstances and landscapes. So it's important that we as practitioners stay focused and stay sharp in our game, so that we can always put the needs of the child and the best interest of the child first.
Okay, good. Thank you for that. Sorry, yes, the next one I see is Christian that has his hand up.
Hi, good day, everyone. I'm Christian van Heestien. I'm an attorney based in Bellville in Cape Town. I historically did my articles and mostly practiced in commercial law. Never really felt as if it was my calling. Went into a more corporate direction for about a year and then joined my father in a partnership afterwards. As life would have it, family law and child law just sort of came over my road at that point, and I really started enjoying it quite a lot. I got in a couple of urgent child law applications that I had to do during the course of the year, and various divorces and so forth. And especially with the urgent applications, I was able to take some of my experience in corporate law and carry that over into the formal process, more so than the law itself necessarily. But I've really started to enjoy the child law quite a lot and decided that I would like to focus my practice into it a bit more.
Okay, good. Thank you very much. It's good to have somebody from that side of the country also, from the beautiful Cape. Okay, and then Lance, you have your hand up.
Good afternoon, everyone. I'm Lance Paul. I'm an attorney at Nelson Mandela University, the Refugee Rights Center. We assist all asylum seekers and refugees throughout the Eastern Cape, and I predominantly deal with children's matters. So I was hoping that this course will expand on my knowledge to provide more comprehensive services to them. Thank you.
Okay, good. Thank you very much. I think it's nice for me to have somebody, a few people that brings also that academic knowledge, because I say this is purely a practical approach to child law and some of the issues we deal with. And I mean, there's a lot of things that we don't touch on. So thank you for that. Then I see this is Charlotte that has a hand up.
Yes. Hello, I am Charlotte Tron. I'm an advocate in Centurion, and I've recently done my first case in the children's court, and I found that I need much more information and experience, so never too old to learn more.
No, that's very true. No, that's one is never too old to learn. And I had a master when I did my pupillage that says that in any way, if you get to a day that you say, oh, no, I know everything, you can't teach me anything, that's the day that you should actually stop practicing, because that's very dangerous.
I agree.
If you reach that stage of arrogance, you're in the wrong place. You must always be have a place to learn, especially with children. Yeah, they change and we need to change with them. Okay, I see who else. Thanks, Charlotte. Who else has a hand up? Who else wants to say something? Yes, Liesel. Hope I pronounce your name correctly.
Hi, can you hear me?
Yes, now I can hear you.
Okay,
yes.
Sorry. Yes, Liesel. I'm also from Cape Town, Bellville. And yes, I haven't been doing family law for many years. I come from a conveyancing background. I do like and prefer family law, and I'm currently busy with the children's court matter. So that's why I've got a lot more to learn. So yeah, looking forward to the course.
Okay, good. Thank you very much. It's strange that you all say you fall into family law and then you like it. And I think sometimes it's one of those things, either you like it and you like the messiness of it, because I say family law and especially children's work is messy. People bring you the messy stuff, the issues. I sometimes feel like I'm parenting parents, and I really get tired of parenting parents.
Very true. I enjoy that part.
Yeah. So if you find it, if you're comfortable with it and you're okay with it and you can do it, I think that it's very rewarding. Jody, I see your hand to do that. So it's interesting for me that some guys like the conveyance, because for me, and I'm sure you will tell me I'm wrong, for me, as conveyancing is clean law. Somebody's buying a property, so everybody is happy. There's no issues. Maybe there's a few issues with the transactions, but otherwise it's like, it's clean law. So it's interesting for me.
Yeah, it's definitely cleaner, yeah.
So it's interesting for you guys to say now, okay, no, let me get into this. But yeah, so it's maybe also something about your affinity to work with people, and maybe help them to solve problems.
Yes.
Yeah.
Yes,
okay.
I enjoy that part, yes.
Okay, Jody.
Thanks.
Hi everyone, my name is Jody McComas. when I underwent my articles, and before that I did an internship that basically just focused on family law. After I was admitted as an attorney, I worked at a legal insurance company, and also I did the CSS. However, I've always had a keen interest in family law, more specifically when it comes to child law. I am currently a family law assistant at the office of the family advocates in Mitchell's Plain. So I basically deal with Section 21 and Section 33 matters on a daily basis. And we try to resolve disputes by way of mediation. And then we also assist the family advocates when it comes to the investigations and matters that is referred to our office by the children's court that specifically focuses on mediation. So yeah, I thought let me sign up and just see if there's maybe tips I can get from this course. So
I think we're going to ask you tips. I think you should have said to us that you're from the Family Advocate's office. Because I think we all go like, what's your name? Okay, Jody. Okay. And Jody, what's your number? Because I'm sure there's all of us that's going to ask you now, okay, we have this problem at the Family Advocate in Johannesburg. What's that? So I think you're also very brave to tell us you're from the Family Advocate. I think you're either well loved or well hated, so it's one of the two. Yeah, but I think the place that you work in Mitchell's Plain is very challenging. I think you have a lot of social issues. So yeah, that would be also interesting to hear from your side how you deal with all those yucky social issues. Yeah. Okay. Thank you for that. Noliyisu, I see your hand is up.
Good afternoon. Can you hear me?
Yes, now we can hear you.
Okay, I'm Noloyiso Linda Nkonzombi. I'm based in the Eastern Cape at East London. I work for the Department of Justice. I'm a legal admin officer. I am an attorney. I got admitted in 2020. In my time of practice, I did a few family matters, and at the Department of Justice, I deal with complaints. And it's mostly from family law. So I thought, let me register for this module and get more information so that I can be able to resolve some complaints, with more knowledge.
Okay, good. Thank you very much. And then Boitumelo. And welcome from the Eastern Cape. I'm glad we have somebody from the Eastern Cape also. Yes, Boitumelo. See, you're still muted.
Oh,
there you go. Now I can hear
everyone.
you. No, I can hear you.
My name is
Evening.
Boitumelo. I'm Cape Town and Strand. Admitted, what was it, 2018. Did some work on the forensic side with Deloitte. Kind of post-COVID, I sat for a bit. I returned to work, and I've been with Updraft. It's really the contact center where I work as a legal advisor. And so you get various queries, are family related. And so I thought it'd be a good opportunity to just up my knowledge and hopefully get some tips on, how to practically what's necessary to help the clients that call in.
Okay, good. Yeah, I think you have the call center. Yeah, it's a difficult job because everybody is calling you to fix their problem now, and you need to have some kind of answer. I need to apologize for the dogs. I have not been able to teach them since COVID to not bark while I'm busy with meetings, Zoom meetings or Teams. So I do apologize for the dogs in advance. If they do bark here in the background, I apologize for that. Thanks, Boitumelo, for that. Did I hear you right? You said you're from the East Rand.
I'm actually in Strand, Cape Town, but I was.
Sorry, that's why no. Now you broke up there for a few seconds, and I think I only caught the Rand, so didn't so the Strand. Okay, so okay, no, that's fine. But are you originally from Gauteng?
I'm an East Rand girl. Brakpan, Benoni, all those places.
Oh, okay. So you're near where I'm now based in Tembisa, so you know that valley.
Yes.
Okay. Okay. Is there anybody that still wants to tell us a little bit about this themselves? And then I just want to just do a few housekeeping arrangements so that we all know how going forward, how to do what and what to expect. Okay, good. Boitumelo, your hand is still up. It's just an old hand, or is it something you want to still ask?
No, I forgot to take it down.
No, I'm just double checking. I don't want to ignore you and then talk over you and then you still wanted to say something. So you will see in the program, you have to submit an assignment at the end of the course, which will be marked. And the assignment will consist of 6, let's call it questions, scenarios that you have to answer. And what I will do is I will release them on specific dates and not all at once. So you can then work on them, as I release them. What I found last year that worked very well is that, and it's your choice, is that I created a little WhatsApp group with all the participants, because a lot of times, technology is not always our friend. I might post a topic and say, and I'm expecting that all of you have received the email, that notification that the topic has been posted, but then you didn't receive it because of whatever technology or load shedding issues that we might have. So what I usually do is I will then on the WhatsApp group just do a little message to say I have posted the topic, the next topic on that you need for the assignment, so that at least you know that you can go and have a look and then start with that topic. So if I'm gonna put my number here in the chat box. So please send me your number, and then I will create a little WhatsApp group. Needless to say, please send me your name with the number, so that I know what to do. So it's not compulsory. It's just a little housekeeping thing that makes the communication. And then also, if you have questions on a question maybe that I've posted as part of the assignment that you don't understand, you can deal with it on the WhatsApp group. There's also once every week on a Thursday evening, there's an hour that I will be, let's call it online, that if you post questions, I'm there to answer it for that hour. If the question is posted outside the hour that I'm on the forum, I will see it, but it's not going to be an immediate answer. So if you have a question about the material or about the course, but it's not like something you want an immediate answer on, it's maybe just something you don't understand, you can post a question there. When I then go online on a Thursday evening, you can then I will answer that. And that's also what nice about the WhatsApp group, that if there's an immediate problem, like for example with the webinars that go, that to follow this one, if maybe you want to attend, but you can tell me, look, I'm stuck in traffic, I'm on my way, something has gone wrong, or I'm going to be a bit late. There's just an easy way for us to communicate with each other. Any questions so far? Okay. You can also, if you want, I see Linda, thank you. That's also an idea that you can just post your number in the chat facility on the Teams. That's also, I can also find your number that way, or you can send me a WhatsApp or with your number. It's either way. Either way, I will create the group and then take it from there. Okay. Any questions so far? Yes, Susan.
Just a quick question. For how long does this course run?
I see the dates is from today or from yesterday until the 30th why? Is there confusion somewhere about the dates?
Yes. When I registered for the course, it said November until 30 November. So I just wanted to make sure end of October or end of November.
Oh, no. There's 24 October till end of November. Sorry, did I say October? Sorry.
Okay,
yeah,
no, 100%. No, I just wanted to have clarity about that.
Okay, sorry. Now this morning, it's a good thing that apparently my months is really not working out, because apparently yesterday I sent an email to somebody to say that I will see the children in July, and luckily the mother was awake, and she said, "Do you mean October?" I said, yes, October. So yeah, I don't know what happened with my months, but really apologies. Yes, so it is from yesterday, the 23rd of October till the 30th of November. Yes, so quite right.
Thank you so much for clarifying.
Okay, Anna. Yeah, and please remind me if I talk about a month that has passed, just put up your hand and say, Elizabeth, that month has passed. Sorry about that. Yeah. Okay, so basically the webinars is a little bit to take you to some of the, let me first say this is a self-study course. There's no way in the webinars that we're going to have time to go through each and every aspect of the of the chapters. So what I will do is in the webinars that we have, I will touch on some of the topics in a chapter. So just basically a bit of a highlighting of maybe something in that chapter that I think that you really should take notice of. But ultimately, unfortunately for you, it is very much something that you have to sit down and work through the material yourself, and then be able to answer some of the questions. You'll see also, if you look at the I don't know if any of you had the opportunity to start going and look at the chapters, but you'll see at the end of every chapter, there's a question, sort of a self-assessment activity, self-assessment question. So once you've dealt with the chapter and you go to that question, you are fairly able to answer that question. I think you are in a position then to say, okay, I've been able to take in the material of that chapter, and I've been able, it seems I'm understanding what the chapter is all about. So you see, that was always the purpose of that little self-assessment, is to test your comprehension of the chapter that you just dealt with. The assignments, unfortunately, or the topics that I will put in the assignment, does not come from these questions. So there's different questions that I will put in for your assignment. So these are just really for your self-assessments. But it will help you also. You'll see also what I changed this year that I thought that will make it a bit easier, because a lot of us are in court and case law, and you must address the magistrate or the judge on certain case law. So in the chapters that deals very much with certain aspects around parental rights responsibilities, the best interest standard, Hague Convention, those things, I've made separate tabs in the chapter that you can just click on, and it will take you to the relevant case law for that topic that we are busy with. So that's also a bit easier in terms of going back to my idea of making this a practical thing. I'm going to court today. What do I put in my bag? I can quickly look at the case law around a specific topic, and you will see also there's a different separate chapter that we will get to. The Amendment Act has been published in the Government Gazette. It has not been implemented yet, but I thought it doesn't help me we're talking about the Children's Act and various sections of the Children's Act, but I do not tell you what is the possible amendments that will come into effect if they publish and the president signs off on the amendments. But that I've put in a separate chapter, because I didn't now want to confuse you by going into the chapters, let's say the best interest standard, and then start making footnotes and little side notes to say, okay, please remember this is going to change if and when they implement the amendments. So that's why I thought, let me rather put it in a separate chapter that is easy to reference. And if during the course of our online course for the next 8 weeks or so, or not 8 weeks, but they do publish for some miracle or another. I will tell you the date that it's going to take effect, but unfortunately it's not. And you all practice in different jurisdictions. It seems some courts, and again, this is the one thing about the children's court specifically, which frustrates, I think, a lot of us, is that they tend to do things like they want and don't always follow the same rules, because I do understand that in some jurisdictions they've started doing the guardianship applications or dealing with guardianship, although those amendments have not been put in place. It has been published yet, but it hasn't been put in effect yet. So it's important that you just keep those few things. But we will look at those amendments in the last webinar. Okay, any questions up to now? So the first chapter is the chapter on the best interest standard, and I put it on its own because it's a theme that I'm sure you all are aware of that runs throughout. If you deal with foster care, if you deal with adoption, if you deal with Hague Convention, if you deal with various things in the Children's Act, this phrase best interest comes up every time. And it's also the most, I almost want to say, abused term in the Children's Act. Because if you ask somebody, why do they want to do this? No, it's in the best interest. But what does that mean? The other day, I had a meeting with parents, and I also said to the parent, okay, why do you want this? No, it's in the best interest. So I said, okay, but what does that mean if you say it's in the best interest? Because people get stuck on this best interest. And it's true, before the implementation of the Children's Act, there was not a simple, the best interest was very much defined in case law, and there was no specific definition for it. So I understand that there is still maybe this vagueness about it. But if you go to specific section 7, and that is in part of and that is in your chapter, sorry, and I'm just using my tablet on the side just to open the checklist. So I called section 7 of the Children's Act. It is what is the best interest. It says best interest, and section 7 then gives you 13 factors of what is the best interest. And I call it a checklist. Because for me, especially if I'm a curator in the matter and I have to do a report, and I see some of the social workers now, when they write their reports also, they also use it as a checklist. They take each subsection of section 7 and they address it. Because it's so easy then to say, yes, we have the best interest, but what is that best interest? And then to take each subsection. And sometimes the specific subsection of 7 won't be applicable. So for instance, there's a subsection that deals with disability or chronic illness. So your specific case might not have that. So you can then say, okay, that factor in terms of section 7 is not applicable to my case, but a lot of the things are. So I'm not going to attach on a few of them, so you can just have an idea of what I'm talking about. So 1A, it talks about the nature of the relationship between the child, the parent, the caregiver, or a really relevant person. So I would say this is a factual question. What is the relationship? And just important, a caregiver, it's always, you'll see throughout the Act also, they talk about a parent or a caregiver. And a caregiver in the Act has a very specific definition. It says a caregiver is any person that a parent or guardian other person than a parent or guardian who factually cares for a child. And it includes a foster parent, a person who cares for the child with the express or implied consent of the parent, a temporary safe care parent, a head of a child and youth care center, person at the head of a shelter, a child or youth care worker caring for a child in the community, a child at the head of a child-headed household. So again, caregiver, if you look at the definition thereof, is very wide. So if we then go back to question 1 in terms of the checklist, what is the nature of the relationship between the child, the parent, the caregiver, or any other relevant person? Because that's an important place to start. And this already speaks to the fact that the Children's Act is not, I always get frustrated and get upset and apathy. It is not the Parents Act. It is the Children's Act. And here already in section 7, you can see it is wider than just mothers and fathers. It is also caregivers. And what is the best interest of the child in relation to that person? Because I think a lot of times we deal with cases where I sometimes feel that the parent stands on their rights, and that we don't focus on the child, because we are so focused on the rights of the parent. But this is not only for parents. So that's your first question. And then the second one is becoming more and more of an issue. The second one, it says the attitude of a parent towards a child and the exercising of parental rights and responsibilities in respect of that child. So what is the attitude of a parent or caregiver towards the other person holding the rights? And that is a difficult question to answer. Because how do you determine attitude? Because I'm going to say you have a bad attitude. And then you're going to say to me, okay, but how does a bad attitude look? It is a difficult thing to define. But this is a lot where you get your alienation, your gatekeeping is here. Because I have a bad attitude towards the other holder of parental rights responsibilities, I am influencing the child against that person. So this is an important factor to take into if you go through your little checklist to see what is the attitude. And the social workers, and Jody will tell you from her own training, and you've learned it yourself also, the one thing the child needs is approval. And the approval must be, it is okay to love the other parent or the other caregiver. It is okay. Because in the absence of that approval, the children suffer. Because now they start like choosing there. And a child is a person like all of us. And I sometimes this morning again, I was thinking, for some reason or another, we sometimes want to make the child more responsible or a better person, or they must meet higher standards than an adult. But a child is just a person like you and me. And if we are put in front of a loyalty crisis, we choose. Maybe we choose between friends, but we choose. And that's the same with the child. They choose because they cannot deal with this negative attitude of a parent towards the other parent. And I think with teenagers, it's easier because they have a different skill set. But for smaller children, it's not so easy. They don't have the skill set to deal with those kinds of emotional upheaval. And what do they do with this negative attitude? So then C is the capacity of a parent or caregiver to provide in the needs of the child emotionally and intellectually. So this is usually what we will talk in a general term of parental capacity. What is that parent's capacity to be a parent? And it can be limited. It doesn't mean because it's limited that that person cannot be a parent, because then we'll have to go and remove lots of children in South Africa. Because all parents have different capacities. But if that parental capacity is to the detriment of the child, then we must start asking questions, because these two are also linked. If you think about it, attitude and parental capacity. If you look at something like, which is sad, but a lot of times people that are adult survivors of some kind of abuse, they tend to want to protect their children against that same abuse, even though it's not real. So then the question is about their parental capacity. Can they separate themselves from their own trauma? Have they worked through their own trauma? Or are they now making their trauma part of this child's life, which is unfair towards the child? So that is the question, the parental capacity. And unfortunately, this is a lot of times where we now get this, sending the people for the psychological evaluations. Because how do you determine somebody's parental capacity if it's not by way of a psychological assessment? And it is ridiculous. I'm sure all of you can testify to the fact how expensive this is. And my question then is, what then if there is no money to do this? How do you then deem, or how do you determine parental capacity? And my opinion, I think sometimes there's a if you look at, let me pick on Mitchell's Plain. People in Mitchell's Plain, maybe I hope I'm not being biased. I'm sure they don't have 200,000 Rand to pay for a expert report. So do we now say, oh well, we're not going to look into the question of parental capacity because we cannot appoint an expert to do a psychological assessment? I think some courts, I know in Tembisa, the presiding officer has found a way around this, and he treats an inquiry as a trial. So everybody testifies. He leads evidence. You must come and tell your story. Everybody can cross-examine. If you want to call 10 witnesses, you can call 10 witnesses, because then you come and tell your story, and everybody and the court can ask you questions and test what you say in terms of your own personality or your own the situation of the matter. Because ultimately, isn't that also what courts are there for? They must make a decision based on evidence. And maybe in my opinion, I think we've gone to a place where we always want to send the children and parents for assessments. But what if there's no money for it? What do we then do? Do we then give up on the child because there's no money for the assessment? So just something to think about. I don't have an answer. I maybe have more questions than answer. Then some of the other aspects is the likely effect of any change in the child's circumstances, including the effect on separation from a parent or sibling. So that's why I say this is a very nice checklist that you can say, what is in the best interest of a child in a specific case? To say, okay, let's start. What is the relationship? Oh, no, okay, he has equal relationship, or she has an equal relationship with both parents. Okay, tick. We can say tick that box. Attitude. Oh, no, both parents have a good attitude towards the other parent, so that's not the problem. What is the effect, and both parents' capacity? Tick. No, they're both good. Okay. Now the question is, maybe the one parent wants to move to, where does everybody go to nowadays? New Zealand. And the other parent going to stay behind. Then the question we're going to ask, what is the effect of that change? Because all the other boxes are ticked. We can say, no, everything is okay. We're still on an equal basis. So is this the factor that maybe will tip the scale in favor of the one person or the other? And ultimately, at the end of the day, if you go through all of this, this is what you want to do. You want to use this checklist to see almost where does the scales end in terms of maybe one parent above the other parent or caregiver. Let me not talk about parents the whole time. That because otherwise, how do you determine what is in the best interest of the minor child? And you see A lot of it talks about a child staying in connection with family, extended family, with the culture. And the difficulty, if we go back to my example of the one parent immigrating to New Zealand, one of the factors here is what is the practical difficulty and expense that that will have to now be put in place for that child to still have a relationship or contact with the other parent. Is there some way that expense of traveling to New Zealand can be negated? So if you want to take the child with you to New Zealand, how are you going to, what suggestions are you going to make to negate the expense of, I don't know what the ticket costs to New Zealand, I think about 13 or 14,000 Rand. And if a child is gonna old enough to fly alone, is they going to accompany him? So that is then starts a practical. What if that question is, well, that is going to be a detrimental, because there is no money here to negate the distance. Should the child rather not stay in in South Africa? So those are the questions you will have to ask yourself if you then work through this list of 13 factors to determine what is in the best interest. And then the last one, which is a very wide one, which is actually nice, to say which actions or decisions would avoid or minimize further legal or administrative proceedings in relation to the child. That's a very wide, because it is actions or decisions would avoid or minimize further legal or administrative actions. And I like to use this section when it comes to, let's send the child for another assessment, then send the child to this, and let's do this, and let's do this. And by this time we're in here into a litigation, and this poor child has been to every woman Tanny that, there's possibly is. Is that in the best interest? That consistent actions, legal or administrative actions the whole time, is that in the best interest? Are we exposing this child continuously to various people, and is that in the best interest? So if that's maybe something you can use as the last to say, no, let's stop this bus. This is not in the best interest of the minor child. Also, remember, this links to, if you go back to chapter 1, it says that all proceedings with regards to children must have certain principles in mind. And you'll see that it says that those principles are protect, respect, and promote and fulfill the rights of the child, not the rights of a granny, a grandfather, a mother, father, aunt, uncle. No. The ultimate principle of the Act and the sections therein is to promote, protect, respect, and fulfill the rights of the child. So I say, if we are here for the respect, if we say, child, we respect you, is it respectful to treat you in a certain way? Is it dignified to treat you in a certain way? So that's why I say the best interest standard, and it says in the Constitution, in the Children's Act, it says the best interest standard is paramount to anything else. And then it goes back to section 7 that says what are those 13 factors? If we say best interest, what is it that we talk about? What is it that we mean when we say that? Okay, so any questions about those, about section 7? Okay. Then we're going to just have a look at chapter 2 and 3, and then we're done, and then we can do overall questions also. So chapter 2 deals with parental rights and responsibilities and the holders of those parental rights and responsibilities. And it's important that we all talk about parental rights, responsibilities, and care and contact. But it's important that we understand what does that mean? Because parental rights and responsibility consists of 4 elements. Let me call it that: care, contact, guardianship, maintenance. Each of these factors or terms has a specific meaning. So if I say I'm the holder of parental rights responsibilities, it has a certain meaning. Then we must say, okay, care, contact, maintenance, guardianship. Also, when they wrote the Children's Act, the ladies of the Law Reform Commission specifically stepped away from the terms of custody and access, because they said custody has a very proprietary idea or meaning. If I have custody something, it's almost like I'm owning something, I'm holding something. And they said that can never be that, like we own a child or we hold the child. No. So they moved away from those terms and they said, no, let's say that people that a parent, a granny, somebody else can be the holders of parental rights responsibilities. And this is also here where the distinction comes in. Not only parents can be the holders. Anybody else can also be the holder of parental rights responsibilities. That is what the Act says. The Act says I can share my parental rights responsibilities with someone. Going back to the Children's Act, when they wrote the Act, they said, well, in real life, children are sometimes raised by grannies, by aunts, by older sisters, by older siblings, by, like we just said, the caregiver, somebody that with consent of the parent are looking after the child. But now you have this, let's say this granny that's looking after the child. That granny has no rights. So what about if this poor child must go for medical treatment or something must be consented to? So the theoretical idea, and I'm sure in practice it's still not happening, but they said that theoretically these parental rights responsibilities can then be shared with the granny or the aunt or the older sibling. So at least that person that is the day-to-day caregiver of that child can at least exercise some rights and make it easier to look after those child. That is why then they looked at this term and gave it specific, let's maybe almost call it subsections. What does it consist of? But then each holder has either automatic rights or not automatic rights. Just interesting, it was when they first did the draft to the Children's Act or the amendment, they inserted a proposed amendment to say that natural fathers will get automatic rights under certain circumstances. I see when they eventually published the amendments, they took it out. Was part of this chapter on parental rights responsibilities is section 21, which is unmarried fathers and how they get rights. Because it's sort of, if you go down the hierarchy, mothers have automatic rights. Because they're the child's mother, they have parental rights responsibility. A father that was married to the mother at the time of the conception or at the time of the birth has automatic rights. When it comes to unmarried fathers, there is still this gray, I want to call it a gray area of when do they get rights? And I think initially when they planned the amendment and they wrote in this automatic obtaining of parental rights responsibilities, I think the idea was that they want to try to move away from the section 21 sort of either you do this or either you do that or either you do this and then you get rights. But as unfortunately they didn't include that in the final amendment. And then also other people can get parental rights responsibilities. Also note that parental rights responsibilities can be suspended or terminated. It is not something that the courts easily do. I know in some cases where I have Act for Children that says they don't want contact with the father or the mother. Actually, they just they don't want the father to have rights or the mother. It takes on average about 2 years, 2.5 years for that court officially to make a decision on that. And they will usually not make it like a terminal, like no, all rights are terminated. They will usually say, we suspend your rights subject to, you must do A, B, and C. And if that person doesn't do A, B, and C, the rights on it just never reinstated, but it's not terminated. It's almost more suspended until that other person does X, Y, and Z. The specific matter that I'm talking about, eventually the court said, okay, you don't have any rights currently, but if you go for a psychological assessment, and there was another requirement, I can't remember now, then the court will relook your rights to the minor children. Needless to say, he never went for the psychological assessments, and it's now been, I think the one child is 17 and the other one 16 or almost 18 and 17. So it's academic in any way at this stage. Even if he does go for the assessments, it's academic. So the courts are very reluctant to terminate the rights. And then guardianship, as I say, currently the High Court has still exclusive jurisdiction over guardianship. Unfortunately, it leads to other problems, and that is then the traveling of the children outside the country. Because as it stands now, you need both guardian's signature for a child to travel, to get a passport to start off with. And then a lot of your visums and those documents want also the consent of both guardians, but that's in any way what the Act says, they must consent. And that is a problem. I recently had a child that he's an excellent rugby player. He got a scholarship to some or another school there in the Paarl area, and they're going on a rugby tour to, I think, Dubai. Father is nowhere, or if they do find him, then he wants like a whole list of requirements of when he will sign for this child to travel. But I mean, it's paid for this trip for the child with the school is sponsored. It's paid. I mean, he's part of the team. He's one of the excellent stars of the team. And now the father's just like, no, I'm not gonna sign. First do X, Y, and Z. And it's usually in those circumstances that the maintenance are also pulled out. No, but then I don't want to do this or don't want to do that. Now, the Children's Court cannot deal with this matter. So now you need to go to a High Court because we are talking about guardianship and the guardianship doing away with the consent of a guardian. If they can just get the Children's Court that jurisdiction, it will be much easier for children. Now currently in our office, we have a child that also won a trip on some or another sea cruise. Now the other parent is again saying, no, this child is not go. I'm not going to sign for a passport. This child cannot go on the cruise. Now we have to start this whole thing of a guardianship application to the High Court to get permission for the child to go on a cruise. If you really think about it, the ridiculousness of it. It's not even as if, I mean, I can understand if the child is going to a country where you think, maybe, the parent is not going to bring the child back. It's just a sea cruise. So it really becomes a bit ridiculous. But I also understand the safeguard of both guardians signing for travel documents, because you might get somebody that's going to try to say, that they're going to leave the country without the person's knowledge, and then it's too late once they have left the country to try to get the child back. So, I understand the safeguard of both guardians signing, but it is unfortunately only the High Court that can do that now. Also, I know some maybe in your jurisdictions, currently the High Court, both in Pretoria and Johannesburg, they want a social workers report to deal with the guardianship application. Now, in the environment that I work, our clients don't have money to pay for a social worker. So we need to depend on social development one of those places to give us a report. They say, no, we're not going to give you a report. And now what? And again, it's usually the guardianship applications that in any way that we deal with a lot. It is usually where the parents have passed away. The child is living with an older sibling, with the granny, and that granny needs the guardianship letter, as how they call it, for pension money, for maybe inheritance coming to the child, and then they can not claim it because there's no guardianship letter, as they call it. So again, this whole idea, and I'm too afraid to think of how many children out there are not accessing all the services that they can because the person looking after them is not the guardian, is not their guardian, not because they don't want to be the guardian, it's just because getting to be the guardian of somebody is so complicated. So at the moment, in terms of just the process that you need to go through. But currently, as the Children's Tax Act stands, that is unfortunately how it is. So just to touch quickly on Section 21, to say that if unmarried fathers will have full rights and parental rights responsibilities, if they were in a permanent life partnership with the child, with the mother of the child, they consent to be identified as the father of the child. They apply to the Children's Court in terms of Section 26 to be identified. They pay damages in terms of the customary law. They contribute or in good faith attempt to contribute to the upbringing of the child or to the maintenance of the child. So these are all, so you don't, it's not like a checklist that you have to tick all the boxes. It's one of them. I know some people then ask, how do you contribute in good faith? Because I know a lot of your clients, I'm sure, have come to you and say, well, you know, I've tried. And now he or she says, no, but take your money. I don't want your money. Because there is still this belief that if I take your money, I get rights, which is absolute nonsense. Your rights to contact is absolutely, there's no connection between maintenance and contact. And I have a colleague that used to say that there's not a price tag through the ear of the child. You're not paying entrance fee to your child by paying maintenance. The two has nothing to do with each other. But there is unfortunately this belief that I've accepted maintenance, then I'm giving you rights. So usually what I would say to the clients is, you know what, if you've tried to say, yeah, here's my 500 Rand, here's my 600 Rand, go, you know, or yeah, I'll buy school clothes for the child, or yes, you know, I'll go and buy groceries for the child, and the other parent says, no, I'm not touching your money. Go and open a Capitec account or an Absa savings account or whatever, and just pay the money in there every month. Because ultimately that child's going to be 16, 17, 18, and they're going to come looking for you and say, okay, you know, but where? And you can say, you know what, I've tried, here's some money, you can maybe use the money for something good at that stage. So that's the good faith. Yeah, how do I'm attempting to contribute. So put your money where your mouth is. Do something with that money. That if you then maybe, even if you approach a children's court later on to say, I want rights, you can say, but yeah, I've really, in terms of Section 21, I've in good faith tried to contribute to the upbringing or the maintenance of the minor child. So that's Section 21 of the so Section 26 is important. Also, there's some exclusions to that. So if a child is conceived through rape or incest, the unmarried father cannot get rights. Or the unmarried father was merely a gamete donor for the purpose of artificial insemination. Then there's no rights. It is interesting, and that's a debate altogether for another day. I think it was in New Zealand or Australia. There was a guy that went around and his favorite pastime was to donate sperm for artificial insemination. And they started to take a dim view of that because the idea or the argument is that it's irresponsible, that he just goes around and donates his sperms to various sperm banks for the artificial insemination. And there's now some consequences, and those countries are also looking at legislation to sort of change the way that they deal with these gamete donors or the sperm or egg donors, because, you know, it becomes, there is other social consequences to that. So I said before, you can, in terms of Section 23, usually in terms of the Children's Court, we will talk about Section 23 applications where you have the granny or somebody else to that applies to the court to get rights in terms of Section 23. I currently have a matter in the Pretoria North Children's Court, which is it's complicated, and the question is, how do we give rights now? Because it's a same-sex couple, and they had a family member's boy in their foster care. Now they have split up. But the child, going back to Section 7, has a relationship with both fathers. But now the child is in foster care. And you can't split the foster care now. I mean, the foster placement cannot be divided like that. So how do you give rights to the, let's call it the ex-father, or the one that's now moved away? Because there is a clear relationship between the child and the one father. He's also the family, he's the uncle in terms of the family. So, but the child has the best relationship with him. But how do you then give rights to the other father? And the suggestion currently is that we might look at the Section 23 to give him some rights in terms of that, so that he can have access to the boy who really wants to see him. I mean, he enjoys spending time with him, because that is who he knows as his other care, or as his other father. So those are just a few highlighted things, and you see some of the legislation, not the legislation, sorry, the judgments I referred to in that is the deal specifically with grandparents. Because I know that's always a question, and I'm sure your clients always ask you, but I'm a grandfather, I'm a grandmother, I want to apply for rights to my grandchildren. And it's usually where there's a death of the parent of their child, or divorce. And you know, usually when the parties separated, the grandparents, unfortunately, most of the time also suffers because of the divorce. And then some of them want to say, okay, but now, you know, I really still want to have a relationship with my grandchildren. And the question then is, how does the court look at that? And you'll see from the case law that I've uploaded for you, the courts again go back to, sorry, what is in the best interest? Again, going that golden thread of Section 7. And here, unfortunately, a lot of times where the grandparents go wrong is their attitude, because they have no problem in voicing their absolute horror or criticism of the other parent. And now of let's say the primary caregiver parent. So now they have absolutely no qualms in telling the children, your mother or your father is bad, she's this, she's that, but now I still want a relationship with you. And the court has said, wow, again, do we place the children in this situation where they go and visit a grandfather and a grandmother that is then has this absolute horrendous attitude towards that parent? Why must we expose the children to that? Is their primary relationship with that primary caregiver, mother or the father, not more important than the possible relationship with giving rights? Remember, we're talking here about giving rights, and you understand, I mean, you all know that once there's a court order to say that granny has rights, and that the court order is not adhered to, I mean, there's other consequences. So the courts then say, well, should I give rights? Should I give that specific right to that grandparent? And we're not so sure the grandparent is going back to Section 7. What is their attitude? Saying that children can't deal with, and especially with that. I mean, if you're going to ask a child to choose between a grandparent and a parent, 9 out of 10 times the child is going to choose the parent. And why do you expose the the child to that. So that's a very fine balance. And you see the courts have also approached it like that is, do we want to expose the children to that kind of conflict? Okay, any questions about that? Okay, the last thing that I want to touch on, and I know it's coming late and you all had long days, so the one thing that I just want to touch on is that in terms of the next chapter deals with the children's court. And then there's always this question about what matters can the children's court deal with and what matters can they not. So there was a case, and I do refer you to it, and it's part of your training material, that had a look at all of this to say, because you will see section 1. Sorry, yes, there's a hand. Sorry, I didn't see your hand. Let me see. Marina?
Yes.
Yeah.
Sorry. So I'm dealing with a matter with a grandparent that's going to apply in terms of section 23 right now for rights now. But this is something very strange to me, and it's the first time that I'll be dealing with it. I know there's no standard rule, and you have to go and see section 7 and the best interest and so forth. But I'm faced with two challenges in that what is a normal point of leave? From where does the court start? Is it type of like a father's rights every second weekend or something like that? Is there something that has come out in case law for grandparents which is kind of a standard from where they go?
You mean the frequency or the kind of rights?
Yes,
Yeah.
For specifically contact.
Yeah, I think, well, first of all, I think we must look at the children and their time. And then the question you have to ask yourself, if you're dealing with teenagers, that teenager already has a gazillion things that they need to do over the weekend. And if there's already a divorce, then most probably, or separation, these children are already being split between two sets of parents. So they're already on some kind of alternative weekend schedule. So now where do you find the time for the grandparents? So that's sometimes a practical approach to say, so look at the guys and say, this is who the children are. This is who they need to visit in terms of a primary care system being their parents. So if we're then going to say to the court, okay, where do we think going to be a good time that they can then visit these other parents? It's going to be in only a holiday. So because you're quite right, there's no fixed sort of rhythm that like you would get or suggestions. It's going to be a practical approach, because you will have to go and look at your children, their lives, and then say, okay, we think it will be a good solution that maybe only over in holidays, where there's lots of weekends, lots of weeks, lots of days, that they maybe go and visit the grandparents. But then maybe also, let's say, they can have telephonic contact. Nowadays, we must also think outside of, we're not stuck nowadays still only with the traditional kind of contact. You know, if the grandparents can have FaceTime, can have video calls, there's different kinds of contact. So to answer your question, sorry, I'm not answering your question, but I think to answer your question is look at your set of facts, look at your children. Are they young children? Are they teenagers? And then say contact is not only what we traditionally have seen as the visit or the alternative weekends. There's so much kind of contact now. So what kind of contact can you put in place for these children in these situations that can be practically, that is something that can happen?
Okay. Thank you. And the second thing was that the other party to this is now claiming that only these social workers are mandated to address the court on the best interest standard. Well, I've checked everywhere. I have no idea where he finds that. I've got no idea who.
No, because you see that in terms of this section, and you'll see it's later on, this act specifically talks about a designated social worker. And nowhere in the act does it say a designated social worker only belongs to social development. There's no such thing in the act. It says a designated social worker. And if I look at, let me just quickly drag my Children's Act nearer. The definition, I doubt also if they have a definition. I haven't looked at it recently. Let me see if I can find the right word of the right place. Yeah, it says a designated social worker. If you look at the definitions, section 1, it means a social worker in the service of the Department of or Provincial Department of Social Development, a designated child protection organization, or a municipality. Okay, so it says it means a social worker in the service of DSD, a designated child protection organization, or a municipality.
So
if
sorry.
Yeah.
Are these the only people who are mandated to address the court on the best interest of the child? So
No. This is where, if you find in the act, the court refers a matter to a designated social worker. This is what it means. So those three categories of people, but it was their form 2 to the court that you applied with.
This is a matter on a matter that started out with the immediate removal of the child, and it's now ending with grandparents having contact rights.
Okay, so there would have been a designated social worker somewhere in that process, because that's what the court have to do. The court has to appoint a designated social worker to do an investigation in whatever. But there's nowhere but a designated social worker, in terms of the act and regulations, must report to the court on a whole variety of things, of which best interest is but one. I mean, they will go and do backgrounds, but it is not to say that they're the only ones that can have an opinion, because a lot of times you will have in any way, one social worker will do a background report on a parent that lives in Durban, and there's no DSD there, so they will appoint a specific organization, and then in the other jurisdiction, DSD is involved, so they will do it, and then ultimately those reports are all submitted. So they know there's no such thing as they're the only ones that can do that. No.
So if there's a designated social worker on the case and you want to introduce a child psychologist report, that can be done.
Yeah, and then you have to go to section 46, which then says that a court can make an order for experts to give the court guidance on a variety of things. But also going back to, remember, that's why I said section 7 is so helpful. Because you need to, if you look at those list of 13 factors, you need to answer them. And some of those questions you can only answer if you have some kind of expert report. So if the court asks you why you want to introduce this report, to say, well, Your Worship, if I refer you back to section 7.1, I'm just picking one now, C, for example. There says the court, for the best interest, the court must be able to answer this question. And your submission is that the only way that the court can answer this question is by looking at this report. And also remember, in terms of social workers, and I'm sure Jody will also be able to help you there, social workers and psychologists have very different roles, and they're not allowed to sit on each other's chairs, if I can call it that. So if the evidence that you want to introduce is then within the sphere of only a psychologist, for example, the DSD social worker does not have that qualification to bring that evidence to the court, that type of evidence. Because she's a social worker with a specific qualification, with a specific mandate. And she's not allowed to go out like any of us. I mean, if we're a lawyer, we cannot now be a mandate to do something else. You must be a lawyer. And the same with social workers and psychologists. So if they're giving you trouble to say, you're okay, you know, I hear what all of you say, but I'm going to refer you to Section 7. I'm going to say the best interest of the child trumps all of you. It is paramount. And for the court to answer this question, I need this following information before the court. And the only way to do it is through an expert report on X, Y, and Z. Because how else must the court make a decision?
Yes, no, definitely. So different people can report on the best interests.
Yeah, I think also be careful for the Department of Social Development. I know they're busy writing new regulations. And in those regulations, but it's not been put in place, it's only been circulated for comment. They're looking at having like a one-stop child assessment, drop-in kind of reporting center with units that will deal with everything. But that is a pie-in-the-sky dream, that they are now seeing themselves as the custodian of all things dealing with children, which is all good and well, but it's not there. And there's nothing to say that you cannot introduce evidence. And ultimately, the children's court is still a court. And the court, the rules there is rules that they've actually written for the children's court that I've given up on, because they're still translating it in all 11 languages, and they haven't published it yet. But there is also to say, the rules is any civil court, you can introduce the evidence of an expert witness. So yeah, now don't listen to the DSD workers.
Yeah, thank you.
Okay. Okay, so the one last thing that I want to touch on, if there's no other questions, is this thing of what kind of matters the children's court can deal with. So there are some exclusions, and it is leading to some issues also, is that it says the children's court is excluded from hearing any of the following matters: flowing from the administration of estate, Divorce Act, Maintenance Act, domestic violence, and recognition of customary marriages. So then there was this whole question, but what is arising out of? The most issues we come across is of divorces. And also this whole thing of forum shopping, because you'll find that a lot of times people are busy with the divorce in a regional court or in a high court, and then all of a sudden, sorry, my voice now decided to start going, decide to go to the children's court. And it's usually because they're not quite so happy with the way that the divorce is going in either the high court or the regional court, and then they start forum shopping. So there was a special review that was sent to the High Court, and it's an Afrikaner matter, and you'll see it's part of your training material, where the court specifically looked at this idea of what is excluded and what is not excluded. And you'll see the court in the High Court went quite deep into certain aspects, but what they came to the conclusion was that if a child is in need of care and protection, even if there's a pending divorce, the children's court will have jurisdiction. Because when it comes to the question of children in need of care and protection, the children's court is the court that has jurisdiction. So yes, even though there's a pending divorce in the regional court, the children's court can deal with children that is in need of care and protection. So the next question then a lot of times arises, but sometimes people go to the children's court, start a matter, and then afterwards they start a divorce. That is fine. The children's court can then finalize that inquiry because they started it before the divorce was instituted. So it's not arising out of the divorce. There was no divorce when the case started. the question here that you need to ask is that if that referral to the children's court while there's a pending divorce is really one of a child in need of care and protection, or is it a parent that is making up something to try to make out a case of care and protection. And if you look at section 150, and that is also one of the other chapters that I will look at that, there's specific factors that the court must look at to see when is a child in need of care and protection. So prima facie, if any of the following factors are present, a child is in need of care and protection. So be very careful, because this is also now where this new, well, not so new thing comes in of parents saying, oh, the child has been sexually abused. Because they know if they say that, prima facie, that child is in need of care and protection, and then they can carry on with the case in the children's court. Like the magistrate said today, I was in the children's court in Randburg, she said that even though you hear the allegation of sexual abuse, and even if you want to go like, really, after 6 years, 7 years now, all of a sudden, you cannot. The court has an obligation, if somebody comes with that allegation, to do an investigation. And that immediately takes that whole question then out of the divorce court and then deals with it in terms of the children's court, but then in terms of specific sections in the Children's Act. So come back to the question, yes, as long as if it's arising, so if the fight is about parental rights and responsibilities, and they're just not happy with the way that the matter is going in the regional court or the high court, they cannot just jump forum and go to the children's court. There must be a case for a child in need of care and protection. But as I said, there's a very nice judgment then that deals with that. So then chapter 3 that deals with the Children's Act, you'll see we look specifically at section 46 in terms of what orders the court can make, which is very important. So if you remember nothing else, I'm sorry, about this chapter that deals with the Children's Court, you must remember section 45 and 46. 45 deals with the type of matters a children's court can deal with, and 46 deals with the type of orders a children's court can make. Remember, a children's court, unfortunately, it's a court of statute. So if you cannot find your type of matter in 45 or 46, the children's court, or 45, the children's court doesn't have jurisdiction. But luckily, you will see section 46 with and 45 also. There's some nice section in there that is very wide, that you can really go, and if you color in your application nicely, you will be able to fit it into one of those subsections. For example, just if I look at section 45(1)(a), it says any matter may involving the protection and well-being of a child. Now, sure, I mean, protection and well-being is wide. So there already in the first subsection, you'll find something that you can say, okay, this is a matter that you can bring in the children's court. But then also you need to read, if you draft your papers, if you deal with a matter like this, you will have to then go also look at 46, because 46 will tell you, for example, what kind of order you can ask for. Remember, the children's court ultimately is still a court. So if you bring an application, you must be able to, yes, I can bring this application. It's a matter dealing with the protection and the well-being of a child, but then you must go to 46 and see where in 46 you might be able to find the kind of order, the type of order that you are seeking, and is it in 46. But you'll see one of the 46(1)(k), for example, says any other order which a children's court may make in terms of any other provisions of this act. So again, very wide. If you can't fit in your order in terms of 46(1)(a) to K or J, then somewhere in the act there might be a way that you can color in your order that you want, that you can fit it into the children's court. For example, in one of my children's court matters, actually 2 of them, we were, in terms of 46, we were able to get an order that the dog must go with the child to his new house because the mother refused. The child was removed, and Frikkie, the Jack Russell, couldn't go with the child to Bloubergstrand because the mother refused, and Frikkie was his pet and his emotional support. So ultimately, I got a court order that Frikkie was moved to the sea from Pretoria. But you need to go and search for it because nowhere in the Act it says that anything about pets or anything like that. So it's more about the emotional support. So Frikkie is now living, hopefully, I must actually check in to see if Frikkie is still living happily by the sea. But in terms of the children's court, that's why I say, if you remember nothing else, 45 and 46 are the 2 subsections or sections that you really sort of need to look at and make sure that you can find something in there to help you. Okay, this is, I think, enough information for one evening. I'm sure you're all tired and you must go. You want to go and have some dinner and relax after a long day. So any other questions? So what we'll do with the next, I see, Colleen, I see your hand. What we'll do in the next webinar is we'll also do a bit of general housekeeping, and then also we will look at the next few chapters of the material, and I will again just highlight some of the material. And also remember this Thursday is my first online session, then please also post your questions so I can have a look at that. And then I will also create the WhatsApp group with all the numbers that were sent to me. Okay, so let me see. I have 2 hands. Let me see the first hand. I see Marina, your hand was first, and then Colleen, I see your hand is second. Yes, Marina.
Sorry. So if you're in the High Court with a divorce and it's pre-divorce and pre-Rule 43 and everything, and custody, or not custody, primary residence of the children is not being disputed, but they currently now live in a situation where the mother and father don't have, they don't want to either move out of the house, and they're now being traumatized by them shouting the whole time and bad-mouthing each other and so forth. But you're in the High Court with the divorce. Where would you go for assistance for those children? I don't even know what type of assistance, but
yeah. Look, I know. Look, the High Court is the upper guardian, so the High Court has inherent jurisdiction to deal with any kind of matter. So strictly speaking, you can bring an application in the High Court to protect them, to remove them, to put protection measures in place. So theoretically, you can do that. My only problem with the High Court is that they're not geared for that kind of hands-on approach that the Children's Court will give you in these kind of matters. Because the Children's Court, if you bring an application, they will appoint a social worker. You will go back to court every 60 days. There will be constant check-ins. There will be a designated worker that can investigation. There can be a removal, place him in a foster. So the mechanisms of dealing with these kind of matters is in the Children's Court. In the High Court, the mechanisms are not there because you and I, everybody that litigates in the High Court will know to get a date is, you have to kill 20 trees to file all the notices just to get a date. Where the Children's Court, once you're in that system, the Children's Act and the rule says every 60 days, every 90 days, you must be in court. There must be feedback. The child worker must do X, Y, and Z. They must report to the court. So it's easier to protect the children. But I know there is a reluctance with some people to approach the Children's Court because they do feel that some of the Children's Court, there's no consistency. If I go to the Children's Court in Pretoria North and I go to the Children's Court in Polokwane, the approaches are different. So you never quite know, what order you are going to get. But to answer your question, the High Court has inherent jurisdiction and they're the upper guardian. So you can actually take any matter to them and ask for intervention and see if they don't want to remove the children or to protect the children. So, but I would personally approach the Children's Court, because clearly if you look at Section 150 and what is deemed to be a child in need of care, clearly children that are being shouted at or exposed to those kind of domestic environment are in danger, of emotionally in any way being exposed to circumstances that is to their detriment.
Okay, so because you're in the High Court, you're not precluded from going to the Children's Court?
No, as long as you can make out a case that the children are in need of care and protection, because otherwise it is something that arises from the divorce, and then the Children's Court are excluded.
I can't find anything about removing a parent from the home. Do you
Oh no, there
protect
is. No, there's in terms of section, you can remove the offender from the, if you look at 46, you can remove the offender from the house. But that's in terms of the Children's, the Children's Act, you can try that in the High Court. And to say you ask for an order in terms of 46, I'm going to lie to you now if I give you the exact, but I'll give it to you. You could ask for the offender to be removed in terms of that subsection of the Children's Act. See if the High Court wants to help you.
Thank you. Thank you.
Okay. Yes, Colleen.
Hi, thanks so much for the webinar tonight. It's already been so interesting and I've learned so much.
It's a pleasure.
Just a question on section 46 and the orders that can be given. I'm not quite sure how far sort of the Children's Court's authority goes. I mean, I realize it's a sort of equivalent for district court, but I've got a matter at the moment that I'm struggling to sort of decide what order to ask for. And I'd appreciate some insights on it if you don't mind. My client is the director of a charity that is sort of a place of safety for children. They are sort of known to the Department of Social Development, but I don't think they're officially like a foster care placement or
they're not registered as such, so they weren't approved as the foster scheme or a foster placement. So
I think they're just sort of a very unofficial place of safety. And my client landed up in a long circuitous route that she landed up with this child who'd been abandoned. This poor kid is very she's HIV positive, she's got mental disabilities, and basically none of the official foster cares or places that deal with children were equipped to deal with her. So she landed up with my client, and my client has approached me to get help, A, sort of formalizing the placement, and B, getting this kid a birth certificate so that she can sort of access all of these things. My problem is that she doesn't really fall in any of the sort of legislative categories, because she wasn't abandoned that you go through that whole process where you sort of apply an age and get social workers to help you. We do know who the mother was, but mother is dead, father is unknown, and this kid just kind of falls between the cracks everywhere. So I'm kind of thinking of approaching the Children's Court in terms of Section 23, because they are looking after her, they are the caregivers. And then asking, in terms of the Section 46, there's a thing instructing an organ of state to assist a child. Could we use that to ask them to get Home Affairs to issue the birth certificate?
Okay, I think you're quite right in terms of approaching the court with the Form 2, asking for a placement, just to safeguard the child to give rights. The court will have to appoint a social worker in any way. That's in terms of the Act and in terms of the regulations, to do an investigation. Because unfortunately, your clients will have to be proved by the court as an appropriate place for the child to stay. And the only way they can do that is if the child sends somebody to go and do a home visit and an investigation to say to the court, no, that's, they're good. It's an appropriate place for the child to stay. They will not be able to be considered as a foster parent because they'll need to go through a whole lot of screening for that, which is also an option.
Yeah.
That is something you can do, but I think it will be first to ask the court, give me an order placing the child with me in terms of 23, just for now, and then ask them also then for a social worker, because you're going to need the social worker to go to the Department of Home Affairs with a court order to register the birth or the late birth, and they know how to deal with the department to get those births registered.
Okay, thank you. And then just in terms of sort of getting this place made a foster placement, I don't even know what the right terminology for it would be. As far as I know, they are like a registered charity. They are known to the Department of Social Development, but they haven't sort of taken the last step where they all go through the criminal checks and all that stuff. But they have already, through this charity, they've adopted 6 other children that have sort of come to be placed with them. Would that not help to sort of circumvent that process?
Yeah, be careful. The department is on a witch hunt in terms of these places that is not appropriately registered. So they must choose your clients. What is they want to be? Do they want to be a foster house? Do they want to be foster parents? And then they are limited in how many foster children they can have with them.
Yeah.
And if I remember correctly, it's 6.
Yeah.
So then, so I think they must sit down and they must choose. What are we? Are we do we want to be a foster, would you want foster parents? Or are we going to register as part of a foster cluster scheme, which has its own specific definitions? Or are they just going to say, you know what, we want to adopt this child, but let's start with, because remember, in terms of an adoption process, the court can also place a child with the prospective adoptive parents, as part of the adoption process. So they'll have to think carefully as to what is it they want to identify themselves as, because if they choose the wrong option, the Department of Social Development is going to come down on them like a ton of bricks. Because I would be very careful to mention the word foster placement or foster parents, because they won't qualify as that if they already have, you see, although those 6 children are adopted, the court is still going to say, well, are you a suitable foster parent in the light that you already have 6 children staying with you? You hear where I'm going. So,
yeah,
foster parents have a specific screening. So I would rather say, maybe we want to adopt, but we're not sure. So let's ask the court to place the child with us in terms of Section 23, so that we at least can start the process. Look, the department and the courts are nowadays very, very careful. Human trafficking, those kind of words are easily used nowadays. And if they think that your clients, and I'm not saying that, I'm not accusing your clients of anything, of there's some kind of shadiness going on here, be very careful. So if I were you, I would just sit down and say, okay, choose a route, go that route. But for now, I would foster, and using the word foster parents, foster placements, I would stay away from that.
Okay, thank you.
Okay.
It's such a difficult matter because there's so much kind of counting against us. And this child, I call her a child, but she's almost 18. So it seems pointless going the guardianship route, but she can't live independently. She is going to need care for the rest of her life. So could you talk more about the scope of what that care is? Does this child have to live with the people she's placed with, like my client? or could she live in this sort of house with house mothers that my client manages?
Well, I think your biggest problem here is that she's not a child anymore, it seems to me. And then the whole Children's Act is in any way not applicable.
Well, she's 17, but
Yeah, but I mean, there's no children's court that at this stage is really going to entertain this, because she's going to turn 18 before the, you know, the whole process is even, you know, is dealt with, and the children's court is then going to say to you, but what are you doing here? She's not a child. If she's mentally has, you know, she's limited, then there's other options for you to maybe approach the part, you know, in terms of, what do they call it, mental health institutions, or get your clients be appointed as a tutor in terms of the administration of Estate Act by the master. Then there's other, you know, options. You can maybe see if you can't get a guardian, because then actually the guardianship will be the quickest, because then as her guardian, they can then still place her in a home, because as her guardian, but that you're going to need a social worker's report for in any way, because if it's only about the placement of her in a home, they're going to need some kind of right over her to get her placed. Then it might be just to see quickly if you can't get give the court to appoint a guardian. But as soon as she's turned 18, you're going to go down the route of curators, or maybe if the master wants to appoint them as they call them tutors for some strange reason, appoint them as a tutor over her in terms of then helping her with her stuff. But your biggest problem is you have to first get her birth registered, because without that, without the birth certificate, she can't get an ID document. Without an ID document, she won't be able to access any service. So first of all, get her birth registered.
But my problem there is, in terms of the requirements of the late birth registration, we need a whole lot of information that's impossible to get. We need, you know, mother's details, father's details, all of this stuff, and we need to have some.
Don't let the Department of Home Affairs. I'm going to take it out of this forum. I have your particulars now. There's a whole. I'm going to send this information that you can, how you can follow the process in terms of the late registration after 18. There is a process that you can follow, but I'll share that with you. If you can maybe just, I did put my cell phone number in the chat. Maybe just send, make sure I have your number, and then I will chat to you further.
Thank you. I really appreciate it.
Okay, good.
Thank you very much.
Okay, okay. Any other questions? Oh, good. So I have all your numbers. Thank you very much. Then I will follow. I formed the little WhatsApp group, and then we'll take it from there. Okay, let me just stop the recording, because I usually stop it too late, and then it's